Hi folks, Bruce Colodny here, the California gun attorney, GunLaw.com, and for over 30 years here in California I've been defending gun owners against California's draconian gun laws, which in my opinion without question are the strictest gun laws in the entire United States. This video is one of three that I've made addressing the subject of why you can lose your gun rights and how you may be able to restore them if you've lost them. Three major reasons why people lose their gun rights: criminal records, mental health reasons, and the subject of this video, restraining orders. Now, there's three types of restraining orders in California that commonly cause people to lose their gun rights. There's also a fourth type, gun violence protective orders, but that's a whole separate subject. Now, the three common types of restraining orders that I deal with in representing my clients seeking to restore their gun rights are civil harassment orders. These are typically neighborhood disputes. You get into it with a neighbor for whatever reason. The cops are called. They advise the neighbors to go get a restraining order. Sometimes I feel like they're handed it out like candy. There's also workplace violence prevention orders. If they get it in your head at the job that you've been talking, that you're a gun person, and then there's a dispute with a supervisor or with a co-worker, they get it in your head you're going to come back and shoot up the job site and take out a room full of people. And then of course there's Domestic Violence Prevention Act orders, restraining orders. And just a word to the wise, the California gun owners, the short version is if you're convicted of a crime of domestic violence in California, you can basically kiss your gun rights goodbye for the rest of your life. That's the short version. So the moral is keep your personal life, particularly your marital or non-marital relationships, on an even keel. Where I sometimes see a Domestic Violence Prevention Act order issued is somebody has asked somebody out on a date 2 or 3 times and they don't get the message that they're not interested. Next thing you know, somebody's down at the courthouse claiming that you're a stalker. So learn to recognize no. Now, these the issuance of restraining orders in California really is pretty sinister in my opinion. And the reason why is that they can be issued on what lawyers call an ex parte basis. And that means they're issued to you, they're issued and take away your gun rights without any prior notice to you. And the reason that's done is California law allows a judge to issue a restraining order if the person seeking the restraining order against you tells the court that you're violent or you've made threats of violence, and that if you were given notice that a restraining order was being sought, that would only increase the chance of violence. And in my experience, more of these restraining orders are issued without notice than are. And in California, the sorry excuse for due process is approximately 20 to 22 days after the issuance of the temporary restraining order. Then and only then you're entitled to a full hearing where you can participate and bring a lawyer, which you should, to tell your side of the story. Now, one of the worst parts of these restraining orders is that they strip you of your gun rights without ever giving you your day in court. I've had people literally call me in a panic on a Friday afternoon after a deputy sheriff or a process server just left, and they're standing there on the phone holding a piece of paper that tells them they have 24 hours to dispose of their firearms and 48 hours to file proof with the court that they've done that. Now, if you're served with one of these restraining orders, you've got 2 options to lawfully dispose of your firearms. You can either relinquish them to law enforcement, which means you take them to a police or sheriff's station, and I think that's the worst option of the 2. The other one is you can sell them to or store them with a licensed gun dealer, and I think you're better off storing them with a licensed gun dealer. Now, you're going to have to pay. The dealers are in business to make money. Each gun they take in requires a significant amount of paperwork to be completed, and they have to earn a living. Now, with your ammunition, remember, keep in mind in California, when you're prohibited from firearms, you're prohibited from all firearms, not just firearms classified as modern firearms under federal law. If you're not familiar with it, just a short a lesson on the classification of firearms under federal law. If it's a firearm made before the year 1899, it's an antique. If it's a firearm that does not use fixed ammunition, in other words, a muzzle-loading firearm like a cap and ball revolver, regardless of when it's manufactured, it's an antique firearm. But in California, the code is clear. The orders are on pre-printed forms, and they tell you two options: relinquish to law enforcement, sell them to, or store them with a licensed firearms dealer. Now, as far as your ammunition and your keep in mind that when you're prohibited from guns, it's all firearms, a firearm frame or receiver, ammunition and ammunition reloading components, and ammunition magazines, clips, speed loaders, any other type of ammunition feeding device. Now, after you've lawfully disposed of your firearms by taking them to a dealer to have them stored, have them fill out the receipt. Normally when you're served, you're given the pre-printed receipt form that you have the dealer complete so that you can take it to court and file proof. And when you file it at the court, take the original and one copy. You file the original, the clerk will stamp your copy and return it to you, and that's proof that you complied because it has the clerk's filed date stamp on it. Now, regarding your ammunition, your reloading components, and your magazines that are not considered large capacity magazines, you can simply give them to a trusted friend or relative, provided they're an adult and you don't have any reason to believe that they're prohibited from firearms. Regarding your large capacity magazines, which in California excuse me, are magazines capable of holding more than 10 rounds of ammunition, they either have to be taken to a law enforcement agency or taken to a licensed firearms dealer that has the additional permit to deal in large capacity magazines. Now, why is timely compliance so important? Well, first off, there's criminal penalties for non-compliance. And in California, believe it or not, when you're prohibited from firearms, if you're caught with even a single round of ammunition, you can be charged with and convicted of a felony. Another reason that it's important to comply is what's known as in California as the APPS program, APPS, Armed Prohibited Persons System. This is the result of a law that was put into effect in California a little over 15 years ago. And here's the gist of what it is. Every day in California, people lose their gun rights. Most people because they lose their gun rights because they're convicted of a felony or certain misdemeanor crimes. And just to digress a moment, beware of domestic violence situations. The short version is, if you're convicted of a crime in domestic violence in California, you're pretty much, your gun rights are gone for life under current California and federal law. It's a rare day when I can help somebody who's been convicted of a crime of domestic violence restore their gun rights. It's just because of the way California law is written, and along with federal law and some adverse United States Supreme Court decisions. Now, back to the what the DOJ APPS program is. People lose their gun rights because of these criminal convictions, because they're detained involuntarily for mental health evaluations, or they become subject to restraining orders. And the court clerks and the mental health hospitals authorized to accept involuntary patients are required to report these firearms prohibiting events to the California Department of Justice, which I often refer to as the DOJ. The DOJ is required to take this list of incoming names of persons who've just lost their gun rights and cross-check it against a database known as the AFS, the Automated Firearm System Database. In California for decades, whenever you've purchased or had a handgun transferred to you through a dealer, a centralized record is created at the state capitol in Sacramento. And the court clerks and the mental health hospitals have to report this. DOJ has to take this list of incoming names of persons who've just lost their gun rights, look in the AFS and see if there are any firearms associated with the name of that person who just lost their gun rights. And if so, they look to see if there's a later dated entry indicating that they've transferred the firearm. If not, they assign your case to their special agents, which are peace officers. They have they're law enforcement officers under California law, and they go out and try to recover your firearms. They rarely have enough current information to convince a judge to issue a search warrant. Sometimes the person who just lost their gun rights hasn't bought a gun in 10 years. So the way they normally work is they show up unannounced at the gun owner's home, 4 or more of them, armed. They knock on your door, announce police, DOJ. You answer the door, they tell you, we're from the Department of Justice. We have information that you have firearms and that you become prohibited from firearms. You have to give us your firearms. I get many calls from people who've been through this. They let the DOJ agents in, they talked and talked, gave them all the guns, and then they were surprised when they were handcuffed and taken to jail. If you get a visit from the Department of Justice special agents, the proper way to handle it is to say, agent, please give me your business card. I'm going to have my attorney handle this. If they tell you that they need to come in and look for your guns, your answer is, if you don't have a search warrant, please leave. Give me your business card and leave. Now, if they have a search warrant, you just sit down and all you say is, I'm invoking my Fifth Amendment right to remain silent, my right to talk to an attorney. No matter what they may promise or threaten you with, that's all you say. Now, you have the right to a hearing. That's that's the excuse for due process. 20 to 22 days later, after you've been served with an order that was issued when you had no opportunity to go to court and tell your side of the story, you have a hearing. It's extremely important that you not go to one of these hearings without an attorney. I have people who will call me in the afternoon when they went to the hearing on their own, they lost, and then at that point it's really too late. Yes, you can file an appeal, but you want to win at the trial court. The difference between trial court law and appellate court law is huge. The majority of appeals are not successful. I mean, sometimes you need an appeal and sometimes your appeal is successful, but trust me, folks, you want to win at the trial court level. All right, that concludes this video. If you have questions about a restraining order that's been served on you, you can call me at my office at 1-800-560-8000. For other information, please visit my website, GunLaw.com. And of course, I'm a lawyer, so now it's time for a disclaimer. The information on this video is general information only. For advice on your particular situation, contact my office. Also, this information is current, but it's subject to change as a result of new laws being enacted. Sure, technically some of our gun laws in California can be repealed, but you know, it's going to snow in July also. Also, on a happier note, the pro-Second Amendment community in the United States has had some tremendous victories in court the last 10 years, so continue to support them. And that's it, folks. See you in the next video.